In this video, I'm going to be discussing comparative negligence and contributory negligence. These are allegations that are sometimes raised by the defense in response to a personal injury or other type of lawsuit. When the defendant alleges comparative or contributory negligence as an affirmative defense, the defendant is claiming that the plaintiff, the person who brought the lawsuit, did something to cause the wreck or incident. There are two approaches for comparative negligence: pure comparative negligence, and in the second is modified comparative negligence. Pure comparative negligence isn't used by many jurisdictions, but it allows a negligent plaintiff to recover so long as the defendant is found at fault. For example, say the jury finds Haley, the plaintiff, 60% at fault for the accident and that she suffered $100,000 in damages. She'll recover $40,000 even though she's the one that's primarily at fault for the wreck. Next, modified comparative negligence. And as if it couldn't get any more confusing, there are actually two types or subsets of modified comparative negligence. They are the 51% bar rule, which is what we follow in Texas, and the 50% bar rule. Under the 51% bar rule, the plaintiff can recover so long as the plaintiff's negligence is not greater than 50%. For example, if the jury finds that Haley, the plaintiff, is 50% at fault and her damages are $100,000, she'll recover $50,000. However, if Haley is found 51% at fault, she collects nothing. If Haley were found 30% at fault, she'd collect $70,000. Now, the 50% bar rule. Under this model, the plaintiff can recover only if her share of negligence is less than 50%. Under this rule, if the plaintiff is 50% responsible or at fault, the plaintiff recovers nothing. This is sometimes referred to as like I said, the 50% bar. For example, let's say that Haley is found 50% at fault and her damages are $100,000. She unfortunately gets $0 there. Now, on to contributory negligence. Jurisdictions, and mind you, there are very few of them that follow the contributory negligence rule, bar the plaintiff from recovering even if the plaintiff was just 1% negligent. Basically, any failure on behalf of the plaintiff to act prudently and a jury finding that is so will bar the plaintiff from recovery. If you have any questions about comparative negligence, contributory negligence, you can always reach us at the office or check out our blogs online. Thanks.